Broadcast is now starting. All attendees are in listen-only mode.
Hi, my name is Amy Hedden. I'm an attorney with the Maryland Volunteer Lawyer Service. We're lucky today to have two people from the Baltimore City Department of Housing and Community Development that are going to talk to us about issues that we definitely see in Baltimore City when we see that a house next door or even the house that we have a client living in is having some structural problems. And so we're very lucky to have Katie Byrne and Doris Weil with us today. And at the end of the broadcast, I'm going to talk a little bit more about available resources that exist out there that we have, in addition to more training. If you're looking for the handout, it's already been preloaded into the GoToWebinar. If you look at you should see a handouts section from the GoToWebinar pop-up, and the full presentation is loaded in there, so you can just download that directly onto your to your computer. And with that, I'm going to turn everything over to Katie and Doris, who are going to start talking a bit more about what we're here to learn about today. Thank you.
Thank you, Amy. This is Katie Byrne, and I'm going to start our presentation today, which is entitled "The House is Crumbling, Now What?" All right, so we're going to move down to our next page. Oh, sorry, that's okay. Oh, it's this one. No, go ahead. All right, there we go. We're breaking the webinar out today into three compartments, basically to discuss the building, fire, and related codes, how DHCD moves forward with enforcement actions, where they start, the types of notices that your client might see. Then we're going to discuss the legal department. So once it gets through our housing inspection division, if the violation isn't resolved, it moves to the legal department, where we have 10 lawyers on staff who file dockets, and we prosecute cases criminally as well as civilly. And we have a dedicated housing court in district court. And then we're going to discuss different resources that are available to you and to the general public to help individuals who are struggling with their property, or you're trying to seek additional information from DHCD to help a client move through matters. So right now what I have on this slide is DHCD's mission statement. So Baltimore is a city of neighborhoods, and DHCD back in 1953, it was the then mayor's plan to try to deal with basically neighborhood nuisances, whether it was a broken fence, whether it was broken down alleys, trash in the alleys, houses that were falling apart, slumlords, all of those issues. So even from 1953 to today, we work together to try to make Baltimore a better place to live, working with owners, working with property owners under the Baltimore Building, Fire, and Related Codes, as well as the zoning code, to make the city a better place to live. And this is a great YouTube video if you want to check this link out. If you enjoy 1950s documentary, you will definitely enjoy this YouTube video. So DHCD code enforcement is split into two divisions. We have property maintenance inspectors, and we also have our construction and demolition inspectors. The construction and demolition inspectors deal with permitting issues. So if somebody has pulled a permit to put on a rear deck, the construction inspector will come out, make sure it meets the minimum requirements under the code. But most of the notices that you're going to receive or that you're going to look at for clients are going to stem from our property maintenance inspection division. The city is divided up geographically. So at the bottom, you'll see where we have the housing inspection area offices. This is main contact for anybody can call them to ask about any violation that's been issued, or even to discuss a property notice. But really what we want citizens to use is 311. If they see a violation in their property, if there is something else that's going on, call 311. It's documented, it's logged. There has to be a response time for the city. So using 311. There's a 311 app as well for anybody that has enjoys technology, you can log in, you can see exactly what's going on with it. The field inspectors issue sanitation citations and notice violations. Now, sanitation citation is a bit of a misnomer. It's not just a citation for high grass and weeds or for trash. It's like a ticket. It's a traffic ticket, and it can be resolved through an administrative process. So it's called a sanitation citation, but any violation of the Baltimore City Building Fire-Related Codes and Zoning Code can be dealt with through a sanitation citation, essentially a ticket. The goal of the field inspectors really is to work with homeowners to help them abate violations. Not just homeowners, but property owners in general. They work with tenants on a regular basis, and they also work with different property owners. So this is the contact information for those divisions. So as I discussed, the sanitation citation, this is what one looks like. So it'll say environmental citation and order. It identifies the address of where the citation is sent, the location of the property where the violation exists, a description of the violation. It gives the person who's receiving the citation an abatement date, meaning they have to fix that violation by that particular date. Now, it's key to look at these things closely because you will have several deadlines in this particular citation. So you see in the example in front of you, it says the date of the offense was December 28th, 2017, and the owner has until January 8th, 2018 to abate, correct that violation. A little further down the citation, it'll say you must pay the citation by X date, and you must, if you wish to ask for a hearing, you have to do it by a particular date. Now, it doesn't go back to the inspector. The Environmental Control Board is a separate entity that's charged with hearing the appeals of any environmental citation issued by the city. So it's not just DHCD, it's animal control, it's the health department. All of those citations are handled by the Environmental Control Board. So with each citation, there is an appeal right. It's crucial that you take a look at the bottom or the second page, depending on how it comes out, to make a determination as to when the last date to file the appeal is, and make sure that that appeal goes to the Environmental Control Board. Once the cat is out of the bag for these, so to speak, we can't pull them back. Now here's a sample of a notice of violation. So the code allows DHCD not only to issue a citation, but also a notice of violation as well. So one or both means can be issued against particular property owners. So this is an example of a notice of violation. Again, the address of where the notice is sent, the location of the violation, a description of what the violation is, but it also gives you the contact information for the inspector and their phone number. One of the things that we tell people all the time is as soon as you receive a citation or as soon as you receive a notice, reach out to the individual who issued it to you. Make sure you fully understand what the violation is. And 99.9% of the time, that inspector is going to work with you and allow you the time you need to make corrections and may even be able to assist you in directing you in the right direction in order to resolve the violation. There also here is a time to abate. So you notice as you scroll down looking at the violation, it says item 1, right? And it says complete within 30 days. There are times that notices of violation are issued and you must correct within 24 hours, 48 hours, or within 3 days. Those kinds of violations are one where there's no water, there's no heat. There are ones that deal with imminent life safety issues. Other ones could take 30 days. Sometimes they're up as long as 45 days. Either way, the key is to contact the inspector, let them know how you're going to resolve it right away. Now, just with the sanitation citation, if a property owner believes that the notice was issued in error or there's something else that they believe was wrong or incorrect about the notice, they have a right to appeal. This notice of violation is not only for violations of the Baltimore City Building Fire and Related Codes, but also for the zoning code. If the notice was issued for the zoning code, the individual must appeal to the BMZA, and there's instructions within this notice as well on how to do that. if it's a violation of the Baltimore City building, fire, or related codes, there's a mechanism to appeal to DHCD as well. So again, paying close attention to the content of the notice is key. Municipal liens. I know that this is right now, particularly we're coming into tax sale season. Municipal liens are, you'll see when someone pulls a lien sheet, they'll pop up and there'll be this miscellaneous lien. A lot of the time it comes from DHCD environmental citations or work orders. So properties are subject to particular liens, water, obviously real property. But if it is not an owner-occupied dwelling, the owner must register it with DHCD. Failure to register results in a citation being issued. Failure to respond to that citation, either through an appeal or by payment, means that the citation could potentially triple, right? If you have a multifamily dwelling, those are also required to be registered. If there's a vacant building, it must also be required to be registered. There are footway and paving bills, as well as miscellaneous bills, special benefits districts. There are all kinds of different municipal liens that are placed on property. But what happens with someone who has an outstanding notice of violation, say they didn't cut their grass or there was trash in the back and a 311 call was made, DHCD or DPW respond, they remove the trash, they cut the grass, and it's all done by an independent contractor. So this is money out of the city's pocket that has to be paid, and all of a sudden your client who's facing tax sale foreclosure, right? They haven't paid their taxes, they go and they get this giant bill for municipal liens. It could be true out-of-pocket city costs for either cutting the grass and cleaning, or failing to register, or failing to pay their environmental citations. There is a process in DHCD. If you discover that these liens came from DHCD, you can ask for a lien review. But as I said before, when these environmental citations are issued, pretty much once the cat's out of the bag, it's out of the bag. If you fail to appeal, that citation stays and it potentially triples. Looking at, if you do not believe that, say, DPW came and cleaned your yard or that they cut your grass, you can ask for a lien review. It's required that anybody that does work on the property, the contractor must take before and after pictures, identify the property that was worked on. Those pictures are uploaded into our internal system. So if you believe, or if your client believes that some of these municipal liens that are generated by DHCD are wrong or inaccurate, you have the right to ask for a lien review. Lien abatements are very difficult to come by. As I said, if the city actually paid for the work, then it becomes a lien on the property just as in real property taxes. Once those citations are out and they haven't been appealed, again, that becomes a lien on the real property. So it's crucial to, again, address it immediately. So if the violation is not addressed, if the property owner isn't, for whatever reason, able to abate the notice of violation, the property maintenance inspector will send the file to our office in order to take legal action. The DHCD Code Enforcement Legal Section can file a variety of actions stemming from different notices of violation issued for every single type of property in the city, not just for residential property, but for commercial property, industrial property as well. Our office files receiverships on vacant buildings, injunctions for what we refer to as standard housing violations. Those would be exterior violations, interior violations, properties that are occupied but in otherwise disrepair. We also file criminal prosecutions for illegal lockouts, denial of essential services, as well as illegal dumping. This is just a snippet from the Baltimore City Building, Fire, and Related Code talking about the legal authority for DHCD to file code enforcement actions. And at this time, I'm going to turn it over to Doris, and she's going to talk a little bit more in depth about the different types of legal actions that are filed by the Code Enforcement Legal Section.
Thank you, Katie. So I'm going to start by talking about receiverships. Again, we're permits and code enforcement legal section. So we're the attorneys that take over the cases after the inspectors were not able to work with the homeowner to abate the violations. So receiverships are authorized in section 121 of the Building, Fire, and Related Codes of Baltimore City. If you haven't seen those codes, do a quick Google search and you'll find a PDF of it, and it's pretty easy to find once you know it's there. In these cases, we petition the court through the mayor and city council through the Department of Housing and Community Development, petitions the court to tell the homeowner either abate the violation, or we can order that a third-party receiver will auction the property. So that's why we refer to them as receiverships. That sounds pretty tough. In my experience, often these cases come about, a house is vacant because, an LLC owns it and decided they were going to flip it and decided not to go forward with it, and just let it sit. Or maybe someone's passed away and they didn't leave the house to anyone. So a lot of times these are properties that really are just sitting, and they're not being used. When we file these cases, we have to give notice to the owner and anyone who might have an interest in the property. So your secured parties, and things like that. Also, we give, the secured parties and property owners are added as defendants in the lawsuit, and then we give notice to the Bureau of Liens and to any judgment creditors. So once we file, if someone shows up to the hearing, the court can give them time to fix the violation. So our measure for that is substantial progress towards abatement. So any defendant, whether it's a property owner or a secured party, can show up and tell the court, listen, we understand it's out of code right now, but we have a plan to abate the violation. Ultimately, what they need to do to abate is get what's called a use and occupancy certificate. That can be applied for online. You get a use and occupancy permit, schedule an inspection, and once you pass your inspection, you get your certificate. That certificate tells you that the house is habitable. That's what we're looking for in these cases. Bring the house to a place where it's habitable and someone can live in it. It can't be like the house pictured there, where it's boarded up and there's no light getting in, there's no ventilation, no air getting in. That certificate abates the violation and the case can be dismissed. Now, that hearing I referred to is a show cause hearing. We file the receivership petitions are verified complaints. That means if the burden is on the defendant to show that they can abate the violation within a reasonable time. If they don't, we have a verified complaint where if no one shows up, there can be an order of default, and the court can order that the house can be auctioned. So the receiver that the city uses is a third-party receiver. It's a nonprofit called One House at a Time. So again, if no one shows up and asks to be appointed receiver to fix the property as authorized by the code, then the city will request that One House at a Time be appointed. Like I said, they're a nonprofit. It's separate from the city, so the city does not take ownership, take title to the property. That's how it's different from things like that require compensation. When I'm talking to my friends who are lawyers, they say, well, don't you have to pay the person for taking the property? And I have to explain, no, it's not a taking. It's the enforcement of the code, and the city never takes title. So Maryland Rule 3-722 sets forth the authority of the receiver, and the court has to set forth in its order the powers of the receiver in these situations. The receiver is going to step in. It's going to vet the buyers who want to apply to bid at the auction and make sure that they are willing and able to abate this violation. They've got to show they've got enough money to perform repairs and get that use and occupancy certificate so that they can use the property for someone to live in. I'm sorry. The property is going to be sold subject to the vacant building notice. That means that that buyer is still going to be under the obligation to fix it, and if they don't do it within a reasonable time, the city can sue again against the buyer. So we do make sure that these things are seen through. The other type of civil cases we file are requests for injunctive relief. These are, like Katie said, the situations where someone's living in the house, but there's either an exterior or interior violation that needs to be fixed because it's either a danger to the occupants or to someone who might be walking by if it's crumbling steps or structural problems. Again, these are occupied properties. What we do in these cases is request that the court order the homeowner to either to abate the violation within a certain time frame. If they don't do that, the court may order a daily fine of up to $500 per day each day the violation remains unabated. And we'll talk a little bit more about how to assist clients in these situations, because this is potentially something more common for MVLS volunteer lawyers, how to help a client with that. We'll get to that a little bit later on. Next, there are certain cases that we prosecute criminally. Any violation of the building, fire, and related codes the code can be enforced either civilly or criminally. These are the actions we regularly prosecute criminally. For the landlord and tenant charges are denial of essential services and illegal lockout. For the denial of essential services, that's when the landlord cuts an essential service such as water or heat without the tenant's consent. In the illegal lockout cases, that's where there's a landlord-tenant relationship and the landlord locks the tenant out for the purpose of basically evicting them to avoid the whole eviction process. These cases are very narrow. These criminal violations are very narrow, but if we get a conviction, it's punishable by up to 10 days incarceration and a fine of up to $500. The process in these cases is that the tenants who believe they've been illegally locked out or denied essential services will go to the commissioner and make a report. That report comes directly to our office. The charging documents come directly to us, and our attorneys do their own investigation to determine whether a crime has occurred and whether we can prove it. So that's something, that can be done for us in kind of a short time frame before we get to court. And just something I'd like to note about this is that these can be very difficult to prove. A defense we often see in these cases for illegal lockouts is the landlord thinks the tenant abandoned, and they're going to try and show that. So these can get a little difficult, but there's something I'm going to come back to. These can be useful for civil landlord-tenant cases, because you might have a transcript of proceedings or a conviction to help you out in your civil cases. And I'll come back to that, but currently there is a potential change coming to Section 915 of the Baltimore City Public Local Law, and I'll have Katie address that briefly.
If you read Section 915 of the current Baltimore City Public Local Law, it's one giant run-on sentence. So not only is it a difficult case for us to try criminally, it was hard to determine sometimes who was a tenant, because you would have people sharing space. They might be in either family members or in a romantic relationship, and then one would file an illegal lockout. So right now, pending before the General Assembly, because it is a Baltimore City Public Local Law, is essentially the law is the same, but it's broken out with definitions, specific information regarding how one has to prove that an illegal lockout or denial of essential services has occurred. So We are hoping that the fix of the giant run-on sentence will make it easier for tenants to understand when a lockout or a denial of essential services rises to the level of a criminal act. We have, just because the landlord didn't fix the heat doesn't mean that they intentionally turned the BGE off in order to force the tenant out illegally. Now, taking doors and windows off isn't necessarily an illegal lockout, right? But no tenant would stay in a property that wouldn't be secured. So we've added certain things that we've seen over the years that landlords have used to try to force tenants out of the property without going through the normal course of the eviction process. So look for that. Hopefully it's gone through committee, it's gone through both the House and the Senate, and we're hoping that that will pass, and it'll be much easier for tenants to understand when an illegal lockout or denial of essential services rises to a criminal charge.
And so now that we've talked a little bit about the different legal actions our office will take, I want to address the ways that DHCD can assist both your clients and the attorneys handling these cases. So first I want to talk about how to assist someone who's received a notice of violation or who is a defendant in one of our cases, whether it's an injunction or a receivership. This can be simple if the person has the ability to make repairs but just needs time, or if they maybe they're trying to secure funding. We try to work with homeowners as much as we can to make sure if they're able to get the repairs and bring their house up to code, that they have that opportunity. So as Katie mentioned before, it's crucial to contact the DHCD inspector who issues a notice. That's where, because like I said, they're going to cooperate with the homeowner as long as they're kept apprised of progress and the person is getting towards the point where their house is up to code. Once you contact the inspector, the client can make the repairs and then schedule an inspection. There's always got to be a follow-up inspection before the inspector is going to basically sign off and abate the violation. So just make sure that it gets formally abated. Now, if they're a defendant in the action, it's kind of a similar process. You just have to work with the court. If you display to the court that your client's making progress towards getting the violations abated, the court is going to do what typically the court will give a person time if they make a reasonable showing that they can make repairs within a substantial period. So there's nothing too complicated about how those work. It's just a matter of if the person has the ability to make progress towards repairs. And we'll talk a little bit about city resources for if they don't have the resources. Next, you may have calls from people who are a neighbor of a property that's out of code, or a tenant inside a property that's out of code. These are issues like, crumbling steps, a roof is leaking and going into the neighbor's property, or for the tenants, their toilet's broken or their water's off and things like that. So whether they're a neighbor or a tenant, you should instruct them to call 311 or use the 311 app, because DHCD cannot take action against a neighbor of someone who's upset about the neighbor's property. We can try to enforce the code as to that neighbor, but we can't take an action in the name of the neighbor. We just do our normal process. So to get that started, this is where you start. If they call on the phone, describe the location, give the address, give the area of the property, say whether it's in the front or the rear, describe the problem with enough detail so the inspector can identify it. That's really important because sometimes the calls just give a block and the inspector can't locate the problem. Residents can remain anonymous for these calls. or they can give their contact information, and our inspectors do follow up with people. So if they don't care about remaining anonymous and they want to figure out what happens, the inspectors will follow up and let them know what they did. And if there wasn't a cause for action, they're going to let them know why. So that's the benefit to, people who don't feel a need to remain anonymous. Now, if your client's in a position where they want to make repairs on their property to come up to code, but they don't have the money, there are some great resources. The LIGHT program is through the Department of Green, Healthy, and Sustainable Homes. They will take requests from residents for all kinds of different repairs. They have housing rehabilitation for major systems, lead hazard reduction, disability accessibility, weatherization. When people apply for their resources, the LIGHT program funnels them through all the available resources and sees what they might qualify for. So for the housing rehabilitation, there's going to be income requirements for them to qualify, and the priority is based on how serious the violation is. If it's something that's someone's out of heat, that application is going to go right to the top and see if the city can help them. Their assistance comes in the forms of low interest loans, forgivable loans, deferred loans, and grants. So there's really all kinds of assistance. Until you make that application, you're not sure what your client might qualify for, but encourage them to do that if they are just trying to get their house fixed so that they can stay there. I know that in my cases, if someone tells me, if I've got a case for, the structure of the porch is falling down, or someone doesn't have heat, if they tell me they've got a LIGHT application, I make sure that I give them enough time to go through that process to see if they're going to secure that funding, because that's really our primary goal, is to keep people in their homes. Now, for tenants who are living in an apartment that's not up to code, again, you're going to have them report it to 311, and then the inspectors are going to come out and inspect it and hold the landlord on the hook for it. So the LIGHT program would be more so for the owners of a home, but if they're a tenant, our inspectors will follow through and make sure that they do whatever they can to get a landlord to abate those problems. Next, I think there's a lot of great resources for attorneys handling specifically landlord-tenant cases that you may not know about. So in this whole process, we keep very good records about any action an inspector takes. They get a call, they make a note in what we call our chip log. It's just by each property and each violation, they're going to write all the activity that happens. They're going to go out each time they inspect, they take pictures, and those get uploaded right away. So if you have a landlord-tenant matter that involves a code violation, you're going to have our business records that you can request to show that the violation exists that was harmful to your tenant. Because the problem in those cases sometimes is that if someone may not have enough evidence, the tenants, especially if depending on the civil action, if it's a rent escrow or they've been locked out or something like that, they might not have pictures of everything. So you can make a request to DHCD for the business records, and if testimony is required, our inspectors do testify on the work they've done. One thing I wanted to note for rent escrow cases, I know that the court will require an inspection, and there are specific inspectors specifically assigned to the rent escrow docket. If your client is living in a house as a tenant with a violation, make sure that in addition to that rent escrow inspection, they're also calling 311. The rent escrow inspector will get you evidence for the court to show there's a violation, but they may not follow through to make sure that that gets abated. Our inspectors do that. So if the client is still in the house, always make sure they're also calling 311 to make sure that the owner gets cited and is required to abate it, and potentially there's another cause of action against the landlord if they don't actually fix the problem. So that's just the difference between evidence in a rent escrow case versus what we handle at DHCD in our office, which is making sure it gets fixed. For the criminal proceedings I mentioned with the landlord-tenant matters, whether it's a lockout or denial of essential services, even if we don't get a conviction, that transcript can be very useful to a civil landlord-tenant matter. So I think I ran across a recent case of ours where we had a guilty conviction that someone was illegally locked out of their apartment. We happened to have a lot of evidence of what was inside the apartment, and the criminal complainant turned around and filed a civil action and was able to get a favorable resolution using the transcript from the criminal proceeding. Those can contain a lot of admissions. Again, even if it's not a guilty, you've got statements of the landlord about what happened and why it happened. So you might get evidence that, solid evidence that a violation existed at the time. So be conscious of that as well. That's another resource you can request through the court. The next bullet point here may be the most valuable piece of information for the attorneys handling civil, like landlord-tenant matters that also involve housing codes. If you'd like to subpoena these records, this is the contact you want to serve the subpoena on for the Department of Housing and Community Development. It's Elaine Harder. She's at 417 East Fayette. When she receives that, she will funnel it to the correct person to make sure that you get your records, and if you request it, and if necessary, the testimony as well. So just keep that address if you do handle those cases. Now, the last slide here is just a bunch of links, things that people may not be familiar with, but that can be very helpful to you. I'm just going to briefly run through these so that you know what's provided here. Our website has the housing code enforcement section where you can report violations, find out who the inspector is in a certain area, view active violations, and photos from inspections. So if you remember, Katie showed you a picture of our sanitation citations and violation notices. You can view those online. You just search by address and put in that information, and you could pull it up right there so that you can see what the notice is. So if someone calls you and says they got a violation notice, in 2015, you can see it online. It's all online. The legal section part of our website will allow you to check the docket, find active cases, view the notices, and again, get that inspector name and contact information. I included here the link to One House at a Time, just for anyone that's curious about the nonprofit that will auction off vacant houses where a receiver has been appointed. Next is the link to the Light Program's website, where residents can get no cost and low cost services to help keep them in their homes. I also have a copy of their application. If anyone would like to review it, I'd be happy to send that along. But they're really helpful if you have questions to contact the Light Program. Next is my favorite tool, Code Map. This is a map of every property in the city where you can basically click on the property and find out the ownership information about permits applied for, any violations, and you can even see a street view. that's a really cool tool to kind of bring all of this together and get more information about the properties you might be working with. Again, if you've got a tenant at a property, pull up code map, search the address, and get some more information about the history on that property. Has the landlord done this before? You know, same with the violation notice in the legal section. You can figure out what's happened in the past and if there are any active violations. Next is that link I referred to for the building, fire, and related codes of Baltimore City. It's direct to that link. It's very long. I recommend using the Control F to find what you're looking for, but that's everything you need about the code that we enforce at our office. And again, we're going to stop for questions in a minute here, but if anyone thinks of something after today, please feel free to email me or call me, doris.weil@baltimorecity.gov. We think that it's not very common you're going to have someone call when they still have the violation notice. So you may have various questions about stuff we've talked about. This is just a really light overview of all the things we do so that you know where to go if you run into these problems. So it's not something you might deal with every day, but if you do have questions, please let us know. And thanks for listening.
So with that, thankfully, Doris and Katie have both agreed to answer questions. If you have questions that you would like them to answer, there's a questions box that is on the right-hand side. In addition, as I mentioned at the start, this program, the presentation has actually already been loaded into the GoToWebinar software. And so if you click on the handouts box, you can download that directly. And all of these links are live links in here. And so if you download it, you'll be able to just click on them and it'll open them up for you. If you wanted to be able to look at some of these really interesting things, including the code map, which I was not aware of, and I'm excited to start looking at that. But if you have questions, please go ahead and type them in. And otherwise, I'm going to talk a little bit about. So this is the MVLS website, which is mvlslaw.org. If you are looking for cases because you potentially want to take a case on. And I can tell you, we do have some tax sale cases that have some of these issues kind of contained within them. But we also see these issues with our rent escrow cases that we have that we take, and a variety of other kind of cases that come through our office. We have some of those cases. You can go to available cases from our website. You click on volunteer and then go down to available cases. And then also, if you're looking for more resources, more training, whatever it is, you can click on the Attorney Resources button. This presentation, along with the recorded webinar, are going to be uploaded to the Attorney Resources section on our website. There's a bunch of other training there, including a variety of training about debt collection. If you want to find out more about our foreclosure training or our tax sale training that we did in conjunction with the Pro Bono Resource Center, we can direct you to that. If you have any training that you'd like to see, I would encourage you to reach out to us, contact me or there's going to be, when you close this out, there's going to be a survey. I would love it if you would complete the survey, tell us what you thought of the webinar, and then give us an idea of other trainings that you'd like to see. And then if don't see any questions, we do have some trainings that are upcoming. If you are interested in quadros, which are sort of the end stage of a divorce case conceivably, or you want to know more about expungement, or you want to know more about human trafficking, we've got some good upcoming trainings on those. But we do trainings all the time, and so just let us know if there's something that you'd like to see. And you can regularly check our website at mvlslaw.org/events for what those trainings might be that are upcoming. And finally, I'd like to encourage you to connect with us on social media. We post a lot of things to Facebook. If you use LinkedIn, we post a lot of things to LinkedIn, but also I would strongly encourage you to include information about your pro bono service on your LinkedIn profile. It is definitely a way to get recognized if that's something that you're looking for. And then we're also on Twitter at MPLS Pro Bono. So it doesn't look like there have been any questions, but fortunately Doris has said that she's willing to answer questions later, and her contact information is in that handout. And you can get that handout either on our website, which will be uploaded a little bit later, or from the GoToWebinar app. And thank you all so much for attending. And with that, we'll say goodbye. Thanks so much.